August 18, 2026, Oakland, California. Inside a federal courtroom, a deputy attorney general rises in front of an 8-person jury and says something no one at Meta's headquarters wanted spoken out loud in front of a jury: that the company's entire business model was built on 4 words: hook them, hold them, harvest their data, hide the truth. She's not talking about a criminal syndicate. She's talking about Facebook and Instagram, and she claims the evidence proving it isn't speculation. It's sitting in Meta's own internal files, written by Meta's own employees. This is the case now threatening to become the largest consumer protection judgment in American history. And the trail of evidence goes back 5 years, to one employee who decided to become a whistleblower. A Facebook data scientist named Frances Hagen quietly begins copying thousands of pages of internal research before leaving the company. What she takes isn't rumor or hearsay, it's the company's own studies, conducted by its own researchers, about the platform's effects on teenagers. Months later, she goes public, testifying before the United States Senate that Facebook's own research showed Instagram made body image issues worse for roughly 1 in 3 teenage girls who already felt bad about their bodies, and that the company knew. In her testimony, she stated plainly that Facebook repeatedly demonstrated it chose profit over safety. It's a single act that changes everything, because for the first time, prosecutors building future cases against Meta wouldn't just have outside research and parental complaints. They'd have the company's own paper trail. As investigators and journalists worked through the leaked files, one internal report title stood out enough to end up quoted directly in the eventual lawsuit: "The young ones are the best ones." Reportedly a description of how the company's own researchers characterized its youngest users' commercial value. State prosecutors allege this wasn't an isolated document. They say Meta's recommendation algorithms were engineered around specific psychological mechanisms: infinite scroll removing any natural stopping point, autoplay eliminating the need for a user to make a single further choice, notification timing designed to pull attention back throughout the day, and like counts engineered to trigger social comparison. According to the complaint, Meta built these features to maximize engagement and never told the public or parents that engagement, not well-being, was the actual design target. The leak alone wasn't enough to win in court. Prosecutors needed years to build a legal case strong enough to survive Meta's attempts to dismiss it. In October 2023, attorneys general from more than 40 states filed a coordinated federal lawsuit, accusing Meta of illegally collecting children's data and knowingly damaging teen mental health for profit. Meta pushed back immediately, calling the claims meritless and pointing to more than 30 safety tools it had rolled out for teens. Over the next 2 years, Meta's legal team filed motion after motion trying to get the case dismissed or delayed. Courts rejected those motions in 2025, and again in June 2026. The case wasn't going away. By the time it reached trial, a core coalition of 29 states, led by California, Colorado, Kentucky, and New Jersey, had a case solid enough to put in front of an actual jury. Before the big federal trial even opened, smaller related cases started reaching verdicts, and each one chipped away at Meta's defense. In Los Angeles, a jury found Meta and Google liable, ordering them to pay $6 million to a young woman who said she'd become addicted to Instagram and YouTube as a child. Then, in New Mexico, a judge went further, ruling that Meta had created a public nuisance by designing addictive platforms that failed to protect minors from harm, ordering the company to pay over $500 million toward teen mental health programs. One plaintiff's attorney told reporters outside the courthouse that they finally had the proof. Legal analysts began drawing direct comparisons to the tobacco litigation of the 1990s, products defended for years as harmless, until internal company knowledge became public and the legal dam broke. When the main trial finally opened before U.S. District Judge Yvonne Gonzalez-Rogers, both sides came out swinging. The California Deputy Attorney General told jurors Meta exploited children's developing brains to maximize engagement and profit. Meta's lead attorney fired back in his own opening statement, accusing the states of cherry-picking internal documents out of context and failing to prove that a single resident was actually harmed. Meta's official position, repeated throughout the trial, is that the case is unsubstantiated and the requested penalties wildly disproportionate. Over the following weeks, Meta CEO Mark Zuckerberg and Instagram chief Adam Mosseri are both expected to take the stand, meaning the men who built these platforms will have to answer under oath for exactly what their own research told them. The numbers alone make this the largest consumer protection case in American history. Meta's own attorneys have said damages could reach as high as $1.3 trillion, close to the company's entire market value. The state's own estimate is lower, closer to $200 billion, still enough to become one of the largest corporate penalties ever handed down. And the pressure isn't just coming from inside a California courtroom. Australia has already banned social media access for children under 16. The European Union has opened its own investigation into whether Instagram and Facebook failed to keep out children under 13. Similar restrictions are being debated right now in the UK, Canada, and France. Whatever verdict comes out of that Oakland courtroom in the coming weeks won't just decide what happens to Meta. It could decide whether the entire attention-driven business model powering modern social media is still legal to build at all. So, the change of this industry might actually affect how we see the internet as a whole. What do you personally think about Meta's tactics? Let us know in the comments.